a default possession only judgment with writ to issue after 10 days.
Can you give me that total again? I'm sorry.
Yes, $3,617.85.
Okay, that's what I thought. All right. Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. River Ridge versus Craig Lambert. And also Sandra Lambert.
I can't get it there. Yes, sir.
Oh,
we're here.
There they are. Hello.
Hello.
All right. And this is a termination.
It is, Your Honor, this is an action for just cause termination of tenancy. Your Honor, an individual in the household by the name of Sean Lambert was charged with and actually pled no contest to felony children accosting for immoral purposes. I believe his sentencing was just earlier this week, Your Honor. And this is a violation of the lease agreement. And in that, the lease prohibits engaging in criminal activity in the community. And so a termination of tenancy notice was issued. And to my knowledge, the defendant's son is still residing in the home. His sentencing looks like, Your Honor, involves 3 days in jail, and he got credit for time served in the amount of 3 days. And he's now on a 5-year probation period that began on March 2nd. So he is now a registered sex offender living in the community, which my client will not allow. Your Honor, Mr. and Ms. Lambert.
I just want to be clear. The basis for the termination, is it because of his status that the lease prohibits that,
The lease
or because of the activities?
It's the criminal activity specifically, Your Honor. This lease that the Lamberts are on was from prior ownership. And does not include the provision against sex offenders. It prohibits criminal activity in the community. However, the community is under new ownership, and leases signed by Mr. and Ms. Lambert for the home that they live at. They own 2 homes in the community, Your Honor. One at the mailing address that's listed on the pleadings, and one at this address. And they live in the one, and their son and his wife live at the other. The lease that the Lamberts signed for the home that they live in is a lease agreement that prohibits sex offenders in the community, because this landlord prohibits sex offenders in the community. But the lease that applies to 105 is prior ownerships, and that lease specifically just prohibits criminal activity. And said criminal activity did occur in the community, and so it is grounds for termination of tenancy.
So, okay, so I think I'm understanding. So the activities that led to the no contest plea are alleged to have occurred in the community.
Yes.
I got it. Okay, that's what I want to know. All right, folks, what's your position on this?
First off, Your Honor, nothing happened in the community. We lived there. We lived for 16 years. Our sons lived with his wife for a year. And this supposedly is for immoral purposes with the children. It never happened. For police conduct, they did all this stuff, the legal stuff on it, reports and stuff. There's nothing in their reports for child molesting or anything. He just was on the phone with somebody, and she coerced him into getting involved.
Hold on a second, sir. I don't know that I want to get into the details. This is going to sound a little bit weird, but I don't know that I want to get into the details of what happened. The question would be, whatever happened, did it happen on the community? Any part of it happened in the community?
No.
No,
All
But
right. Are you guys gonna, was that conviction in Washtenaw County?
It
Yes.
was, Your Honor, the case number is,
It's gonna be a circuit.
it is, Your Honor, it is 25F 41540.
11540. All right. Okay, so we'll get on Odyssey and do that. Are you folks gonna be wish to be represented by a counsel on this case?
we saw an attorney. We had a hard time finding an attorney. We saw an attorney
Okay.
yesterday. He said, number one, there is no lease, but they do have the right to have him leave. And when he leaves out of the house at 105, then we're going to have to sell it because we cannot afford to have two houses.
But there's nothing in the community.
Okay, just never mind. We have no, but what we wanted to talk about is if we could get an extension to give him time to be able to find a place to live and them time to move out.
All right, so here's what I'm gonna do, folks. I'm going to adjourn this out to the 13th next week. March 13th, 2026 at 12 noon. That's an in-person hearing down at the courthouse. That'll give you some additional time to seek an attorney. All right. And you can also feel free to contact the plaintiff's attorney's office to see what you can, if anything, work out.
And Your Honor,
Okay.
just
You guys want to
to
talk-
clarify, Your Honor, I did receive correspondence from my client on or around February 25th, indicating that the Lamberts had complained to her that they had called my office several times and that I wouldn't speak with them, but I had no record of that. And in that conversation, they had told my client that they had an attorney. And so I did not make attempts to contact them because I did not want
You
to
can't
attempt to speak
do
with
that.
them.
Right.
Correct. My understanding is that they were told that if they have an attorney, to have their attorney call me. If they do not currently have an attorney represent them, I'm happy to speak with them. If they intend to retain an attorney or still try to retain an attorney, then I will wait to see what the outcome is of that attempt before communicating with them. But
Got it.
whatever it is, they can call the office, and I'm happy to have a conversation with them to see if we can reach a resolution.
Okay.
Okay, do you folks understand that? So
Yes.
if you're going to be, so that we're clear, if you're going to be represented by an attorney or if you have an attorney, it's not that Ms. Dornbush doesn't want to speak with you. She is actually prohibited from having a conversation with.
Why
We
is
didn't have
that?
it.
We didn't
What?
have attorney. The only attorney there was my spouse.
Folks, listen, the moment you tell another attorney on the other side that either you're trying to get an attorney or that you consulted with an attorney, they're not going to talk to you.
Oh,
They're prohibited from doing so ethically.
okay,
Okay.
The moment you say, I don't have an attorney, I'm going to represent myself, then she would be clear to talk to you.
okay, we don't have an attorney.
At this time.
Okay, then what I'm going to suggest you do is you call her office,
Okay,
speak to her and see
Okay.
whether or not you can work something out. Otherwise, what we will do is we'll see you on the 13th at noon. That's an in-person hearing, so you'll have to come down to the courthouse. Okay?
Okay.
Your Honor, I have a phone number ending 3823. Is that a good phone number for either one of you? If so, I can give
Yes.
you a call today.
yes, I would really appreciate it, honey. Thank you.
Okay, very good. Thank you, folks.
Thank
Yeah.
you. Have a good day.
Yeah,
You do the same.
all right.
Scioto Farms versus Camellia Landry.
Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Good morning, Your Honor. My name is Catherine Perez on behalf of the defendant, and I am requesting permission to represent under the supervision of David Santacroce pursuant to 8.120, MCL 8.120.
Whoa, stop. Is that how Santa Croce told you to say that?
Yes,
He did?
kind of.
I don't
maybe.
think he told you that way. didn't he tell you to say like Michigan Code Rule 8.120?
Yes, he did. I
Yeah,
meant
he
Michigan
did.
Court
All
Rule
right.
8.120. I'm so sorry.
All right. And you've not been before me before, I don't think.
I have not. This is my first time here.
Is it? You nervous?
I'm feeling okay.
Okay. All right. Where are you from originally?
Cincinnati.
Okay. So
Ohio.
you're Midwestern, albeit Ohio. And where'd you go to undergrad?
Ohio State.
Oh, I'm done.
I know.
I am so done. This is really over.
I had to be honest, candor to the tribunal.
What'd you say?
I said I had to be honest, candor to the tribunal.
Yeah. Oh, now she wants to throw out those rules. All right. That's fine. All right, counsel, welcome aboard.
Thank
All
you.
right. What is plaintiff's claim in this case? Permission to
with
practice is granted. Go ahead.
Thank you, Your Honor. With cost, Your Honor, $1,742.42.
All right. And counsel, what's your client's position on this?
We would like our client, the defendant, Mrs. Landry, she has been unwell health-wise. Just within the last week, she was declared incompetent, and then that pronouncement was rescinded by her psychiatrist and physician. She is not doing well, but she was still able to pay through February's rent. And it's our understanding that this case has all been about the client portal, which she's not been able to essentially figure out because due to her health condition and age. And we have not even been able to speak to our client directly because of her health. We've been speaking through a proxy, one of her close friends. And so it is likely that we would need either a power of attorney or a guardian in this case. And just because of all these circumstances, we would like to request an adjournment for 2 weeks.
All right.
A 2-week adjournment.
But what I'm hearing is if you can get through some of those things, it's likely that at least through February, there's going to be payment, right?
Well, there's already been February payment, but yes, likely that we'll get, like, this would not be an issue in further in preceding months or subsequent months.
How much is their monthly rent?
So,
Sorry.
and Your Honor, if I may, the
Yeah.
monthly rent is currently $915. There was an increase as of December 1st. The issue here, Your Honor, is that yes, Ms. Landry has been making payments through February. They are generally speaking paid late. But the issue is also that they're not the full amount. Ms. Landry was sent a lease renewal offer last September. She was reminded of it several times via phone, and including in October, there was email correspondence reminding her that the lease renewal needed to be signed. The lease renewal was hand delivered to her. This was in January, Your Honor, but my client still would have honored the lease renewal had she signed it and returned it. At that time, she told the community employee that she wanted to review it and then sign it and presumably have it returned. But at this point, it had been in her possession for 4 months. It had been previously sent over for her review and approval through DocuSign. But the renewal offer letter setting forth the rent increase, which she's paying, and the month-to-month fee was sent to her in September. As far as the portal situation goes, Your Honor, this came up in the last court case that we had. And my client has really bent over backwards to try to accommodate Miss Landry and trying to get her set up in the portal so she can then do automatic payments and not have to have a physical payment dropped off at the office. My client has gone to Miss Landry's home and attempted to sit with her after she enters her credentials into the system to access her account on the portal to get that going. And they can't do it because she doesn't have a good internet signal, and she won't come up to the management office where the signal is good. And my client can't take her login and password and do it for her. They can't do that. These are her credentials. She has to be present to do it. My understanding from the last court case was that Mr. Santa Croce's office was going to be trying to help her with that if it couldn't take place through management, if they couldn't come up with a plan. The plan ended up being that Miss Landry needed to come up to the management office. She hasn't done so. And unfortunately, the interactions that my client has had with Miss Landry is that when they do try to help her in person or over the phone, she ends up becoming not so friendly to deal with and threatening to call her attorneys, et cetera, at which point my client will then say, then we're going to step away because this is just irritating the situation. And so my client is stuck between a rock and a hard place of trying to get her to a point where she can get her lease signed. She can do the automatic payments through the portal, but Miss Landry has not been particularly cooperative in doing that. My client had made some, adjustments and accommodations to Miss Landry in the last court case with the expectation that the lease renewal was going to be signed for the next term beginning in January, and that this signing up registration through the portal for the automatic payments was going to take care of that, because this has been a continuing issue for Miss Landry, unfortunately, for some time. And so right now we are dealing with obviously month-to-month fees that aren't being paid. And Miss Landry left a voicemail for my client on January 22nd, I believe was the date, indicating that she was aware that she had the lease agreement, that it needed to be signed and submitted. That didn't happen. So she knows what the rent increase is because she's been paying that. But she's not covering the month-to-month fee, which she had notice of. And payments are coming in late.
I think I get it. And in particular, if at some point she was declared incompetent and then that rescinded, some of these conversations probably are taking place during that period in time. And so. Yes.
And Your Honor, I was speaking with Patty this morning and saying if, she's having some difficulties making these decisions and maybe there's somebody that needs to step in that can assist her. If it's been rescinded, then it also draws into question whether or not there was the requisite level of, whatever it was that drove that initial diagnosis. It's been rescinded. Obviously, I don't know, and I don't have access to her medical records to know what the driving factors are on that. Nonetheless, Your Honor, it does seem like she needs some assistance.
Well, but sometimes that can happen. Obviously she's of a certain age, but also some of that can happen just by medication and the medication kicking in, that all of a sudden now they're in a different spot.
Yeah, so and I totally get that, Judge. So I would agree. I think that hopefully there's somebody that can step in and assist her, because it's putting my client, unfortunately, in an awkward situation where, they can only do so much.
Your Honor.
Yes, go ahead, Mr.
If I may, just without, I don't want to argue with Ms. Dornbush. We categorically disagree with her framing of it all. My client has end-stage kidney disease, so that it's the dialysis issues that are causing the mental health issues. She can't use a portal, so the idea that she could DocuSign a new lease, the management's well aware. There's going to be an ADA and maybe a fair housing defense here. We hope to work it out. We have a friend that dropped off a check. But I just want to put on the record that we fundamentally disagree with the plaintiff's characterization. Now's not the time for trial. We need some time either to get a guardian ad litem in place or for her to give a power of attorney to her friend who brought the check in the other day. And we hope to work this out. She's got nowhere to go. And also to be clear about the medical, she has been in the hospital for like 2 weeks. and they're now supposedly supposed to discharge her to a long-term care facility, and she came back down with a systematic blood infection, which is super, like, it's not,
Okay.
she's not in a good place, let's put it that way.
And Your
All
Honor,
right.
if I may just respond very briefly, the lease renewal goes to her email, not to the
Right.
portal, to be
Right.
very clear, number one. And number two, it was hand delivered to her by my client, which they did as a courtesy. And so,
I get all that, folks. Folks, I get all that. I've got somebody that's trying to operate, their business needs the rent paid. I've got somebody that fundamentally may not be able to do it. I think between all of these fine people here, we can find a way to work that through. And it may end up in a situation if she has to go to a long-term care facility that much of this might end up being moot in certain respects anyway. But here's what I'm gonna do. You guys want 1 or 2 weeks to try to sort through this, because you've got to try to figure out either a GAL or at least a payee or something along those lines.
I don't
We would
object
like-
to 2 weeks, Your Honor.
All right. I'll adjourn this to March 20th, 2026 at 1 p.m. And that's an in-person proceeding, but you guys can work it out somehow, figure out how to do that. All right?
Thank you.
All righty,
Thank
thank
you.
you. Thank you, Your Honor.
All right. And thank you, Buckeye. You're all right.
Thank you. We'll see you again soon. Bye-bye.
Yes, ma'am. Scio Farms versus Julie Sharp. Julie Sharp, not checked in. You've been sworn. You may proceed.
Your Honor, Ms. Sharp did make a payment. I think we just need verification that it's cleared, so we could adjourn this 1 week.
All right. Adjourn this matter to March 13th, 2026 at 12 noon.
Thank you. And Your Honor, just so the court's aware, that payment would have cleared her through February. March does remain unpaid, so,
Gotcha. Okay. Court calls case of Scio Farms versus Marcel Doss Jr. and Justice Richter.
I'm here.
Hello. All right. Marcel's here, correct?
Yes, sir.
Got it. All right. What is plaintiff's claim in this case?
with costs, Your Honor, $4,867.58.
Said 4,800.
67 and 58 cents.
And how are you folks going to get this paid?
So we had filed a SER and we were waiting on that. But we were also waiting on our tax return to come in, and we were just going to pay the balance in full because we don't plan on renewing our lease. Well, we didn't get a thing to renew our lease anyway, but we weren't going to renew the lease to stay here anymore anyway. So we just wanted to pay, get a little time to, find where we're going to move next and pay the balance in full this month.
Okay.
But we were waiting on the SER.
How many people are in your unit?
6.
Okay.
Yeah, 6.
There are six people in your unit?
Yep.
Okay. So
No,
if the SER comes.
8.
Eight?
I wasn't counting the 2 adults, me and Justice.
Okay. So I think they only go up to 6 or, well, anyway, that could net you at least probably about 1,000, a little over 1,000 if the SER comes through.
Yeah.
All right. So, sir, what I'm going to do is I'm going to adjourn this out 1 week to the
Okay.
13th, 2026 at 12 noon.
Okay.
And what I'm going to suggest is that you may want to contact counsel to see what you can work out regarding how to resolve this thing. The other thing is that in your rental, in the packet, there was a rental assistance form.
Mm-hmm.
You'll need to fill that out and supply that with the tracking number for your SER. You need to file that with the court by Wednesday.
Okay.
All right.
Okay.
Thank you.
Thank you.
Court calls the case of Sile Farms versus Eddie Edens. Oh, Eddie Edens and is it Trey Hickenbottom? Oh, there they are. All right. Well, I got Hickenbottom twice, but I don't know what that's about. Okay. What is plaintiff's claim in this case?
With costs, Your Honor, $3,662.06. They just made a payment of $2,000, so that balance takes into account that payment.
So the 2,000's come off. It was
It already
5,000.
has. Yeah, sorry, it was 5,000
Okay.
this morning. Patty updated me as to a $2,000 payment, so 36,6206.
Got it. All right. Gentlemen, how are you going to get this taken care of?
I have a meeting with my financial advisor, so I'm going to pull money out of my 401k, and I'll get it paid next week. Well, within the next 2 weeks.
Okay. You said next week, next 2 weeks.
Yes. I have a meeting with my financial advisor next Wednesday, this coming up Wednesday.
Okay.
Yeah.
And then, and even if you then start that process, it's going to take maybe 10 days to get it out, right?
Yeah.
Any objection to 2 weeks, or you want 1 week adjournment, Ms. Dornbush?
Patty, any objection to 2 weeks?
No, I have no objection to that.
All right. So I'll adjourn this to March 20th, 2026 at 1 p.m.
All right.
And Your Honor,
All right.
before these gentlemen
And that-
sign off, Mr. Hickenbottom is signed in, and the spelling of his name is Trae on his Zoom. We have it as TRA. Is TRAE the correct spelling?
I think it's Trey. Yeah.
It's
there's an E
TRAE.
on it.
Your Honor, we would just request to have that corrected, both as far as the court
Yes.
records and any additional pleadings.
Dependents to the name to TRAE. Got it. Okay.
Thank
We'll
you.
take care of that. All right. Thank you.
Thank you.
Court does call the case of Sile Farms versus Kyle Kroll. You got him?
I'm here.
Oh, there you are. Okay, if you got a camera, I need you to turn that on. And what is the claim in this? What is the claim in this case?
$3,187.16.
All right. Mr. Kroll, how are you intending on getting that paid?
I could pay $1,500 today and the rest of it on the 1st of next month.
Okay, so you're gonna pay $1,500 by today, some point, right?
Within the next hour or two, yes.
Okay, so you're gonna pay that today, and then you got to work out something regarding the balance. So here's what I'm gonna do. I'm gonna adjourn this out to March 13th, 2026 at 12 noon. That's an in-person hearing. I'm gonna suggest that you make that payment and then contact plaintiff's counsel's office and see what you can work out to get this done.
Okay.
All right? Thank you,
said
sir.
March 13th at 2.
Pardon?
You said March 13th at 12?
Yes, March 13th at 12.
Okay, thank you.
Thank you. Sile Farms versus Graceland Morrison and Jeremy Hughes.
That's us.
Okay, there they are. All right, what is plaintiff's claim in this case?
Your Honor, my client reported that they made a payment of $150, but there was a question as to whether or not it had cleared on the ledger yet. Patty, were you able to verify that?
Yes.
Okay, so Your Honor, let me just do some math. 3145.24 minus 150. All right, we've got them at $29.95 and 24 cents.
I made a payment on the 4th of $1,500. I have the check number that I paid to BioPharm if you'd like that.
Was that a personal check or a certified check?
It was certified check. So it was a cashier's check that we paid in through them. So when I'm looking at my portal right now, my balance is $1756.24. And
Is how much?
it's $1756.24.
Okay.
Your Honor, we can verify that payment. I mean, the $1,500 payment didn't cure it. And so if we adjourn it, we can look into that payment. I'm not sure.
Okay. All right. So if you guys paid that, when would you, I'll adjourn it out a week, but what's your plan for paying off the rest of the balance?
I'm waiting for my taxes to hit. I'm supposed to be getting around $1,500, and then he's working full time, so that'll come in the next 2 weeks, and so we'll be able to pay that. My only thing is that I am requesting that we have this go out 2 weeks because my first daughter is due next week, a week from today. So I am expecting to be in the hospital at any time. So I could be popping this baby out today or next week or so.
You probably should have led with that, but okay. So, so you're due next week.
Yes.
Yeah.
Okay. And this is your first.
Yes.
Yep.
So it's, why are you saying yup?
No, that's my first.
You know what? Okay. I'm not dealing with you.
I know, right?
I'm talking to her. All right. He's acting like he's got something to do with this.
I know. Yeah.
Right. See, I got it. Okay. I'm going to put it out 2 weeks. That may be over the objection of plaintiff, but
No objection, Your Honor.
March 20th, 2026 at 1 p.m. And what I would suggest you do is once they do that other check, maybe you can call the plaintiff's attorney's office, see if you guys can work something out.
Okay.
All right.
Okay.
Okay. And ma'am, if we don't see you, congratulations to you. Okay. And I'm sure everything will go well. You'll be in our thoughts. All right.
Thank you so much. You guys have a great rest of your day.
All right. And you fella, not so much. Okay.
That's right.
I'm just letting you know that. I'm letting you know how I feel. Okay.
Appreciate it. Have a
Take
good day.
care.
You as well.
And is that it for Silo Farms? It is. That's it for Patty. She actually talked on the record today. She didn't just
Yes, I
take
did.
care, Patty.
Yeah, you too.
All righty. LSG Spice Tree Apartments versus Stephen Kozlow and Raven Weiss. Kozlow or Weiss? They are not here. You may proceed.
Thank you, Your Honor. This is an action for termination of tenancy based on violations of the lease agreement, Your Honor. This was brought under the threat statute. In fact, Your Honor, on January 29th, Stephen Kozlow engaged in threatening and intimidating behavior by making a verbal threat to cause physical harm to the assistant property manager of the complex. Police report was filed, and that's under 26-118. Based on those facts and defendant's failure to appear, we would request entry of a default possession only judgment. I don't know if we requested an immediate writ in this case, Your Honor. It does
I don't.
not look like we did. And so
Yeah.
for that reason, we'll request the statutory 10-day period, but we would ask if the court would indulge in including language that the defendant, Mr. Kozlow specifically, is not to enter the management office.
All right. Judgment to the plaintiff, that is by default for possession. Redemption amount, or there is no redemption amount with a writ to issue in 10 days. I will include, and you can include under paragraph 10 of the judgment that the defendant is not to enter the management office.
Thank you.
Spice Tree Apartments versus Cameron Ed.
Insulin.
Are you taking anything that would interfere with your ability
No,
to
sir.
understand what we're doing here today?
No, sir.
Are you a United States citizen?
I am.
We've had some discussions about your case, Ms. Poole, and quite frankly, This doesn't happen very often. It happens every once in a while where I have a case where I don't really know what to do. You present a problem for me in that you've tested positive while you were on pretrial. You denied that you were going to test positive, and it does not seem like when you were evaluated, you were being completely honest about your usage. You were initially screened for, let's see, back in, when was it? We had you assessed by Modern Psych and Genesis program. They recommended PHP with supportive housing and medication management, which you weren't really interested in. The position of the folks back in the annex that are supervising you seems to be that you don't really tell the truth when you are confronted with things. And I don't really know what to do about that because Ms. Poole, I have sort of what I call my treatment bucket. That is people who have drug and alcohol problems, who acknowledge their drug and alcohol problems and want to get better. That's sort of over here. I have this other bucket, though. That's the punishment bucket. That's people that break the law and just need to be punished and get on with their lives. We also have this third bucket, which is people I need to supervise, so to make sure that they don't commit new crimes. I really don't know which of those that you fit into, but I know that you're not supposed to be using drugs while you're on supervision, and you are. Not supposed to have any firearms around. And I'm not going to have a debate about whether a working firearm is or is not, or whatever was on the table during the home visit. I'm not going to have that discussion because here's what I'm going to do. If you enter a plea of guilty to this charge, I'm going to release you today back on electronically monitored supervision. We had you evaluated to coach. They're recommending intensive outpatient treatment. I'm going to go along with that. You're going to get engaged in that. We're going to come back here in about 8 weeks for sentencing. Hopefully, everything is going to go fine. Officer Wilson or someone dressed like him is going to go out to your house. They're going to confirm that there is nothing that is even firearm related in the house in which you are going to be residing.
Okay.
And you're going to test negative on all of your tests. And if all of those things happen, the next time we come back for the sentencing, I'm probably going to put you into my community control program and try to manage this case in the community. If we can't do that, then you're looking at probably a 4 to 6 month stint in a place like Monday, if it's drug or alcohol usage. And if there's any firearm nonsense, you're probably going to the pen. So that's sort of where I'm at in the case. Mr. Madden probably explained most of that to you, maybe not in as colorful of terms. But other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the second page, maybe, is there a second page? Yeah, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Madden before you signed it?
Yes, sir.
Are you satisfied with the representation that you have received in the case?
Very much so.
You're going to enter a plea of guilty to one count of firearms under disability. That's a third-degree felony punishable by up to 36 months in prison and a $10,000 fine. You're also pleading guilty to the specification, which will indicate that that weapon will be forfeited. We also have the aggravated possession of drugs, which is a fifth-degree felony. If I do have to send you to prison in the case, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty, if they can. They have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You'd have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count one, specification to count one, as well as count four, that on or about July 11th of 2025 in the city of Franklin, Warren County, Ohio, the defendant, Rachel Poole, possessed a concealed and loaded firearm in a motor vehicle with a prior felony conviction involving drugs of abuse. She also was found in possession of methamphetamine, which was lab confirmed at 1.53 grams. This was all after a traffic stop.
Anything on those facts, Mr. Madden?
No, Your Honor.
Ms. Poole, did you hear those facts?
I did.
Do you admit they are true?
Yes.
Do you understand the right you're giving up by entering a plea?
Yes.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We are not going to go into the matter of the sentence today. I'm going to order a level 2 pre-sentence investigation. Also, I'm going to order an evaluation for a community-based corrections facility because I'm not necessarily optimistic about how this case is going to go. We're going to come back here in about 8 weeks for sentencing. Officer Wilson, I think my position in this is pretty clear. If they need time to scrub the house of any of these sorts of things, give them that time. But when we go out there, I don't care if it's a bullet, a tiny little piece of a gun, anything that is firearm related means that she will return with you from the house. Other than that, we'll get you back on drug testing and we'll see everybody back here for the pre-sentence. Anything else?
No, Your Honor. Thank you.
All right,
Thank you.
that's all.
Thank you, sir.
Okay.
Short leash, Officer Wilson.
Yes.
Judge,
Short leash.
did you want house arrest or curfew?
I'm okay with curfew.
Okay,
Logan, do you need me to file another entry?
if you don't care.
I don't care.
It's not there.
So you ready?
All right, let's see.
Cameron Edge, they are not here. You may proceed.
Thank you, Your Honor. There's rent to retain of $3,302.34. Cost of $169 for a total due of $3,471.34.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with the writ issue in 10 days. Spice Tree Apartments versus Leah Graham. Leah Graham or Tamar Reno. You don't have either present. You may proceed.
Thank you, Your Honor. $3,034.26 for rent to retain. Costs are $182 for a total due of $3,216.26.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. Spice Tree Apartments versus Brian Meeks. I think he was here. And Brian Meeks and
Yeah.
yeah. All right. Meeks. Okay.
Good morning, Your Honor.
All right. What is the claim?
With cost, Your Honor, $3,401.91.
All right. Mr. Meeks, how are you going to get that paid, sir?
I'm sorry, I thought it was 3301. I mean, not to be nitpicky, but that's
It's a late fee.
again, okay, because it's in the system, even in their system this morning, it even showed 3301.
Yeah, I think the late fee comes due today. It may not have been added on to the ledger yet, but my understanding is that the late fee comes due today.
Gotcha. Okay. I just paid $1,400 this morning, and on the 23rd, I'll be able to pay the remaining balance.
Okay, so $1,400 you paid today.
Yes.
And so you say you'll have the balance by the 23rd?
Correct.
Your Honor, if Mr. Meeks is agreeable, I wouldn't have an objection to entering into a consent agreement today for that. If he pays on the 23rd, that would resolve this matter. And then I don't have record of the 1,400, but I would indicate that in paragraph 10 on verification of that and clearance of that, that it would apply towards the 340191 in line 2D.
Mr. Meeks, you want to do that?
Absolutely.
All right. Okay, so you understand that you have a right to be represented by counsel you don't have to enter into this judgment. You've been through the process before, so you know how it kind of works, right?
Yes.
Okay, so I would be entering a judgment for the plaintiff finding no tribal issue for the 340191. And that's with a writ to issue on,
You said the 23rd, that's a Monday, Your Honor.
right. So writ will issue the 23rd. That way you don't have to come back. You'll get it paid off. Seems you always do. And we'll get it through. All right,
And I won't
sir?
be back. I will not be
Yes.
back.
Well,
Your Honor.
see, you keep telling me you won't be back. You'll be back. You just show
Well,
up.
I'll tell you this. I'll share this, and also forgive me because when the young lady mentioned that she was an Ohio State grad, I'm a Michigan grad. I typed "who" in the chat all day. Just saying. I had to, but Your Honor, I just want to thank you for being so patient and everything. You're a very nice gentleman, but I don't want to see you in this fashion.
Okay, I won't take any offense at that. I also think you're a nice guy, but I'm getting sick and tired of you too. All right.
Thank you so much. I appreciate it.
All right, take care, Mr. Meeks.
You as well.
Spice Tree Apartments versus Jenna Stribley.
Oh, Your Honor, I'm so sorry. I'm so sorry to jump back, but with respect to the other matter, there was a second defendant. I don't know if Your Honor wants to put proofs on for the second defendant as far as a default goes. Or just
Yes.
indicate it.
I will take what you stated as proofs, enter against the second defendant by default.
Thank you, Your
Okay,
Honor. My apologies. I meant to touch on that.
No,
Got distracted.
I didn't catch it either, so. I don't think she's been involved in the proceedings, so. Spice Tree versus Jenna Stribley and Nathan O'Neill. She's here, Miss Stribley.
Good morning.
Good morning. How are you?
I'm all right. How are you?
I think I'm good. All right. What is plaintiff's claim?
With costs, Your Honor, $2,761.68.
All right. Ma'am, how are you guys going to get this paid?
I made a payment this morning of $1,000 and I plan to make another payment later today once I go to the bank of $400. And then I'm just waiting on my tax return and then I can pay the, excuse me, the remaining balance.
Okay. So, and you don't know when your tax return is coming back, do you?
It's been accepted. I just don't know when I will receive the refund.
Got it. Why don't do you see the $1,000 payment, Ms. Dornbush, or no?
I don't, Your Honor. The ledger that I have is from a couple days ago, so.
Got it. All right. What I'm inclined to do is she's waiting on a tax return and I'm going to trust that she made the payments. Without objection, I was just going to put it out 2 weeks. Let her see if she can get it caught up. All right, ma'am. So what I'm going to do is, because you said you're going to pay an additional $400 later today.
Yes.
Okay. All right. So I'll adjourn this out to the 20th, 2026 at 1 p.m. That's an in-person hearing. If it's not paid by that point, then you'll need to appear at the court. What I'm going to suggest that you also do is after you make those payments, contact plaintiff's office, see if you can work something out regarding an agreement or a conditional dismissal on this. Okay, ma'am?
Okay, thank you very much.
All right, thank you. Whitaker Oaks versus Tamika Bayless. Tamika Bayless, not present. You may proceed.
Thank you, Your Honor. There is rent to retain of $3,734.02. Costs are $202 for a total due of $3,936.02. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested with the writ to issue in 10 days. Whitaker Oaks versus Megan Tunberg. Not here. Tunberg, not here. You may proceed.
Thank you, Your Honor. There is rent retain of $1,729.06. Cost of $202 for a total due of $1,931.06.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. I think that's all I have for you.
I would agree. Thank you, Your Honor. Have a great day.
All right, you do the same.
Thank you.
And you really are my number one now that she's gone. All right. All right.
Thank you for that, Judge. I appreciate that. Likewise.
You take care.
You too. Bye-bye.
14A stands in recess.
Lots to do. Tim, let's take care of your last pretrial cases, and then we'll take care of our guy that's back in lockup.
Mr. Jeffries and Mr.
Travis Jeffries. This is file number 2699SM. Are you Travis Jeffries?
Yes, I am.
Mr. Jeffries, you're charged with operating while intoxicated. We have lots of these on the first Friday. Your employer is Mr. Tim George. They're asking to reset this, restart that with documentation. I'm not sure what that note means.
We have some documentation from my client's primary care physician, as well as he's going to get plugged back into his counseling at Pivotal. So we'd like to have the opportunity to get those documents over to the prosecutor's office before we move forward.
All right, normally, yes. I would adjourn this to the 27th, but you're not available. I'd hate to go all the way to May 1st.
Well, and the only reason I asked for an attorney pretrial instead of a last pretrial, Your Honor, is because my client does work second shift at American Axle. So I didn't want him to have to miss work. If it's something that we can't avoid, obviously we'd like to get scheduled as soon as we possibly can.
I mentioned this before. The first Friday of April is Good Friday, and the courthouse is closed by order of the Supreme Court. I think that's how. Maybe it's just a county thing. Anyway, so we moved the first of the month pretrials to March 27th, and the lawyers had other commitments. Judge Pattison didn't want me to put all these on his date of April 17th. So I guess we're going to reset for May 1st. I hate to go that far. Mr. Jeffries, you do have an unpaid ticket for defective equipment from 2023. You owe $150 on an old ticket that you hadn't paid. I don't know if I reminded you of that previously. I'm gonna give it to you. That's a dumb ticket because defective equipment is the kind that they would excuse if you came in and showed that it was fixed. So what probably happens, you got a ticket, you forgot about it, it went defaulted. It's on your driving record, you're $150. I want you to take care of that. In the meantime, the matter is reset to May 1st.
Thank you, Your Honor.
You're good to go. That's one reason why I want to talk to everybody, to remind them of unpaid fines and costs. Sometimes they have open warrants or there are other issues. This is Tyler Kern.
Yes, sir.
This is file number 252726, charging no insurance. 252727, charging driving suspended. And file 252728 charges no registration plate. You have $822 worth of other unpaid fines and costs, including a trespass, disturbing the peace, breaking and entering, which is probably illegal entry, and a careless driving. We're going to set a last pretrial on this matter.
Yes, sir.
Mr. Kern, are you on any sort of payment plan on that stuff?
I just started paying off my suspended license so I could get it back to.
Well, you're gonna have to take care of this stuff. I could
Yes,
put
sir.
you in jail and wipe it out. Do you want to do that?
No.
I bet not. You've been ignoring this stuff for
Working on it.
6 or 7 years. It's time to get on the clue bus. All right, we'll set a final pretrial. That'll be on a Thursday afternoon. I don't yet know the date. I want you to go out to the court and some of these go on your driving record, like the careless driving and others. Some do not. Illegal entry, disturbing the peace, and trespass don't affect your driving record, but they may affect what I do as a sentence. If I give you fines and you don't pay them, I'm not going to give you more fines. I'm going to give you a jail time. So it would be good to try to start to pay on that. They don't trust me with sharp scissors, so somebody got me some little short ones. Somebody sent it to me, but I got the big ones back out. So far, I managed not to hurt myself. All right, you take that out to the counter. Those are all the things that are still due and owing. And I will reset this for a Thursday last pretrial.
Thank you, Your Honor.
All right, let's do Mr. Montgomery. He's back there in the lockup. We'll try to get him on his way. I'm going to arraign him on his other charge. Autumn wanted me to do that.
Your Honor, is it a possession of a drug double, or is there something else that's charged in there?
I don't even know. Tap that microphone. Laura, we have the same problem we had before. It's not tuning into you, so I'll just do it manually. I'm not sure what's going on. They're about to tear all this stuff out of here within a month or so. Still not working. I just locked it on him.
Oh, okay.
Do you have that file?
No, I checked with district and they indicated you should have everything.
Well, that's the worst case scenario. They gave it to me. I have a felony case.
Good morning, Mr. Montgomery. We met yesterday afternoon. Mr. George was here on another matter, and we did a very brief bench warrant arraignment. In this case, which is 25278 ST. You're charged with driving suspended second offense. That is a misdemeanor. It's punishable by up to 93 days, up to a year in jail and a fine of up to $1,000. It carries 2 points and it requires that your driver's license be suspended. We did a brief bench warrant arraignment yesterday, as I said, and scheduled the matter for this morning. Mr. George, what's the status here?
The prosecutors offer that if my client would enter a plea to no valid operator's license, the driving suspended second offense would be dismissed.
That's a pretty good offer. No valid operator's license, Mr. Montgomery, is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points on your driving record and will go on your driving record. Your license is already suspended, but this will go on there. Do you understand?
Yes.
You understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury.
Yes.
If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, the county could appoint one for you, and they have appointed Mr. George. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
Were you driving a car? Let's look at this ticket again. On February 14th of 2025, about a year ago.
Yeah.
And was your license suspended at that time?
Yes.
You have 2 days of jail credit. You might have some at the front end. He didn't show up last March for Judge Pattison. He issued a bench warrant. And then you got picked up on that bench warrant a couple of days ago. You got arrested in June and posted a bond, and then you bugged out again. So you had 1 day in June, 2 days now. Or 7 days jail, credit 3, leaving 4 days to serve, which is going to be concurrent with your new methamphetamine charge, 26360FY. 0 fine. I'm going to waive your attorney fee also. the minimum fee of $125 or 2 additional days, which should be swallowed up by the other time you'll be doing. I believe you owe me money. I had it on yesterday's cheat sheet. You owe money to the court, but I don't have it in front of me for today. We'll look into that in the other case. The new case is 26360FY. And as long as you're here, the magistrate asked me to just take care of this arraignment. That's not right. 25278 ST. Because I didn't have a bunch of other things to do this morning. All right, Mr. Montgomery, let's take a look at your new case. You got arrested on a charge of possession of methamphetamine. That is in file 26360FY. Complaint alleges that that happened in Montville Township on March 4th. Is this the place where you were in, they did the search warrant? All right, they charge you with possession of methamphetamine as a second or subsequent offense as a drug double, making it punishable by up to 20 years imprisonment. And you've been in custody since that time. I need to appoint a lawyer for you. They didn't give me the dates. I wish they would do that. I'm going to show a plea of not guilty. I don't even have the authority to take a plea at a felony at this level. To show a plea of not guilty, I will appoint an attorney, set a pre-exam conference. I think the dates are March 17th for the pre-exam and March 20th. The pre-exam would be at 8:30, and if a prelim is needed, it will be March 24th at 1 o'clock. In the underlying case we just did, you failed to appear twice. You failed to appear for your first arraignment. They issued a bench warrant. You actually failed to appear 3 times. Then you did appear and you got arrested in June. And then you failed to appear again, and then you got arrested yesterday, or the day before. So in this case, you have appeared, but you previously case you failed to appear. You have an unpaid driving suspended case in 202483 ST. You have an unpaid domestic violence in file 23808 SM. And an unpaid disobeying a stop sign ticket. Failed to appear on the fast, failed to pay fine and costs. And it's a drug double. Set bond at $10,000 cash or surety. They gave me a whole bunch of stuff. Including the bond form. You shall appear personally for any previous or subsequent examination. You shall abide by any judgment entered by this court. You shall not leave the state of Michigan. Do not commit any crime if you are released. Provide email and telephone number on release. Do not use any drugs or alcohol if you are released. No assaultive or threatening behavior. No firearms. You shall seek employment. All right, you're going to be taken back to the jail. The magistrate and the clerk will prepare the bond. If you're able to post it, you need to call your lawyer, make an appointment to discuss this case with them. You got 4 more days of jail to do on the driving suspended case. I don't think you're going to post the bond. I did not appoint Mr. George as your lawyer. He may end up in the rotation, but I'm not sure who's on duty that particular date. But this takes care of your traffic case and gets your felony methamphetamine case started. You told me you were in bed when the cops came and executed the search warrant. I don't know anything at all about the facts in this case. Your lawyer can explore that further. I suspect there's more to this. There usually is. But you can go back to the jail and get lunch. You're good to go. Thank you, Mr. George. All right, let's get some of the last pretrial people out of here. Rhonda, why don't you take over for a minute? We'll do a couple of your last pretrials. And then we're going to just limit it to the plea people. You got about 10 pleas for me. Paul's got 20.
Well, I was hoping you would take Kyle Booty first.
He's
because-
next up. Kyle Booty. Would you come forward, please?
And if I may, Your Honor, at this time, Mr. Booty has decided that he is not interested in the plea offer. And we will have to schedule this matter for final pretrial and trial.
All right, Mr. Booty, you're charged with domestic assault. It's alleged that you assaulted Elise Shanae Pashby, someone you had a dating relationship with. Prosecutor has offered a deferral in this case. You're apparently at this point unwilling to accept that. So you're asking me to set this for a jury trial?
Yes.
All right, are you still at the Highland Drive in Middlebury address?
Yeah.
All right, we will set a last pretrial. I don't see that you owe any money. Now, your bond conditions, you are allowed to live in the state of Indiana. You've made all your court appearances. You're not to have any contact with a complaining witness, no assault or threatening behavior, and you're not to use any drugs or controlled substances or alcohol. You got it? All right, you're good to go.
Will I get something?
Yeah, I've got to figure out the date. We do these on Thursday afternoons at 2:00. So it will be coming up, but I don't generally have the ability to set those right from the bench.
We'll let you know when I get a date.
All right, let's take care of some of the others. Paul's got a couple. Samantha Hoff. Good morning. Are you Samantha Hoff?
Yes, sir, I am.
We've met. You're charged in file 252682 with retail fraud in the second degree. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. You're also charged in file 2638 with another retail fraud and a conspiracy to commit retail fraud. Those are also punishable by up to a year in jail. You've also got $430 worth of unpaid fines and costs. Some of those are booking fees, but you do have an unpaid use of a controlled substance.
I got my receipt.
Oh, you paid it or just paid on it?
I just paid on it.
All right, very good. All right.
I paid district on district court too, and I'm after court plan to pay most of those booking fees.
Don't worry about the booking fees right now.
All right.
Hold off on those. You may need the money for your other fines. All right, we're gonna set this for last pretrial as well.
Yes.
We haven't got, I'm assuming there's an offer, but she's not willing to accept it at this point.
No.
Yes, that's correct.
Are there videos of these?
Well, that's part of it too, is that I think the prosecuting attorney, they only got me half of the discovery material, so I need to review additional discovery material.
All right. Are you still living in Howe?
Yes.
State Road 3? Is that correct?
Yes, that's correct, Your Honor.
All right, now, you're to stay out of these stores. I think it's Walmart and Myers. Walmart and Walmart. I guess you can go to Myers. But we'll set this for a last pretrial on a Thursday afternoon. Get your attorney opportunity, get police reports. The videos, obviously, those are important for you to see. And I'll see you on a Thursday afternoon at 2:00. I don't yet know the date for that.
Okay, thank you. It says Kate, it's like a court person.
What did?
And it says, I'm trying to ask you about indicate reality, Kate also, as her sister, the Smith office listed as involved.
I don't know what that means, actually. CAD, I'll have to figure that out.
All right, Robert Gowan. Good morning. I met you at your arraignment. You're Robert Gowan?
Yes, sir.
This is file 251144SM. You're charged with larceny under $200, which allegedly occurred a year ago, February 21st of 25. The warrant was issued in June of 25, and then you got picked up, I think accidentally, on December 19th. At this point, Mr. Gibson, your client again wishes to have a last pretrial and discuss the matter further.
Yes, I conveyed the plea offer to him and he indicated that he was asking for a trial.
Are there video evidence or other things in this case?
There is, Your Honor.
Do they have it?
Discovery was sent on February 12th.
Dude, if you're doing a gambling app in here, shut your phone off and pay attention. Just put that away. Pretend like you're in a courtroom. Wait for a train. Oh, yeah, this is that thing. It has to do essentially with theft of electricity and perhaps some other property. All right. You're entitled to a jury trial if you want one. We'll see where we go. This seems fairly straightforward. All right. It'll be a Thursday afternoon at 2:00. I don't yet know what time. I'll try to sell Mr. Gibson's on the same day. You're good to go, sir.
The date. I'll have to.
I don't know the date
I
yet.
don't know it yet. Thank you.
All right, John Fox Jr. Morning, Mr. Fox.
Morning.
Mr. Fox, you're charged with larceny under $200 and assault and battery. You're here with your lawyer, Mr. Paul Gibson. You got a bunch of unpaid stuff, $915 worth. Speeding, larceny, animal violation, trespass. They've offered to dismiss the assault and battery if you plead to larceny under $200. At this point, you're declining that plea offer. Is that correct?
That's correct.
You're not at that West Street address. Sometimes you don't show up because I don't know that you always get the notices. What's your address?
Technically, I don't have one. I have a mailing address.
What's your mail address?
Was it
285 Canaris Street, apartment 1, Constantine.
Did he get printed?
He did.
All right. Do you have a phone number that your lawyer has?
He's given
Don't
me
give me the
one.
phone number. You got it. All right. We'll set a Thursday afternoon pretrial at 2:00. Mr. Fox, you're good to go.
Thank you, Your Honor.
One of the pleas that I have, Mr. McDaniel, he's in custody.
See here. Let's take care of him. It's not good for security back there. George. Mr. George. Unlock this, see if this works.
Where is it on?
This is file 251910, People versus Aaron McDaniel. That's you, sir?
Yes, sir.
You're here on a charge of domestic violence, second offense. Let's look at the, Nicole, is this the case you're here on? This is McDaniel?
No, that's not. I'm paying attention to them all.
Oh, well. Mr. McDaniel, it's alleged that on August 27th, you assaulted Gina Huser, someone you had a dating relationship with, charged as a second or subsequent offense, which is punishable by up to a year in jail. Prosecutors agreed to dismiss that charge for a plea to domestic violence first offense. Domestic violence first offense is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Do you understand the charge?
Yes, sir.
Anybody threaten you to get you to plead to that charge?
No, sir.
Or promise you anything?
No.
You've signed the advice of rights with consultation with your lawyer, indicating you're giving those rights up by entering this plea. Is that correct?
Yes, sir.
Who is Gina Huser to you?
Ex-girlfriend.
All right. And were you guys living on Chicago Road at that time?
No, sir. We were both homeless. We are still both homeless.
All right. So this was off Chicago Road by the railroad tracks?
This was by Peterson Spring, or sorry, Iceberg.
Iceberg, all
there's
right.
a factory there. I had a tent back there. She would just come there and stay, and yes.
Now, this was in February, so when was this? It was in August, so it wasn't so cold.
No, sir.
So did you get angry with her and knock her down?
Sir, she came back to my tent late at night, heavily intoxicated. She come back, we had a little altercation. I came out of my tent, at which time she pepper sprayed me when I came out of my tent. And out of anger on my part for her pepper spraying me, I picked a bike up and I threw it at her, not intentionally hitting her, but the bike did bounce and it did hit her in the leg. And that was all that occurred at the time. We both settled down. We both went to sleep that night. She woke up the next day. She was looking for a backpack that she lost. She got mad again, and the next day she continued to fight. I never put my hands on her. There was a the coworkers at Penguin even stated that I never got off the ground. I just sat there and let her scream. She walked away, and that's when she filed this police report.
Well, one witness says you pushed her down to the ground. She fell to her knees. While on her knees, McDaniel stood in front of her and used an open hand to hit her in the head multiple times.
I was released
At
that
this time,
day.
the witnesses observed the assault.
Yeah, I was released that day, Your Honor, because she had no marks or nothing on her. They just said they were going to run it through the prosecutors. They said that they called Penguin, and they said that they stated that I never put a hand on her and the officers that arrested
Well, so do you want to plead to this or not? Did you?
Yes, because I did pick a bike up out of anger, and I did hit her the day previous.
All right.
I did do that to her. Yes, I did. But the holding her down, Your Honor, no, I did not do that. That's why I was released that day from the arresting officers.
All right. You got arrested the first day and you did a day.
Yes. Well, that was following. They released me in August. And then when I was arrested a few months later.
You got arrested in December.
Yes, sir. I
did
did one
show
day.
up for your arraignment.
Yes, sir. I missed my
So
court date for medical.
one day, then you failed to appear again.
Yes, I called the courts and rescheduled, and
So I think you got 30 days of jail credit.
yes, sir.
You have not done very good on your other stuff.
No,
You have a previous domestic violence where you owed $570 and you didn't pay that. Then you had 3 counts of assault and battery in 24 and you didn't pay that.
Yes, I got
So you have
a.
well, you don't have any money, so you don't.
I got a job. I just got a job. My boss said if it works out to time served, he said he will be here to get me today to go to the job.
Well, I'm not doing time served.
I got it.
I gotta get input from her. Plus, you haven't paid your fines and your costs and your last assaultive offenses. And
Yes,
the
sir.
police report reads much differently when your representations were. Had you been drinking when this happened?
No, I don't drink, sir.
Well, that's a plus. Let's see how quickly I can set this. Today is the 6th. Mr. Gibson is set to be here Monday. I don't think you can, she's homeless. I don't think you can find her that fast. Why am I busy?
Your Honor, may I just put a little, I've been homeless for a couple of years now.
Yes, sir.
And this is a really, really good job for me. I've been really trying to get on my feet.
What's the job?
It's in Colon. It's with David Wheeler, really good guy. He just
Doing what?
300 acres of woods and stuff that need to be cleared. He
All
has
right,
me.
well, that can wait.
He has me a place to stay, everything, and
All right, that sounds like a good plan.
yes, and I just won out of Sturgis. It's in Colon, great spot. It's just a great opportunity for me.
Well, it's warming up. You've been in
Yes,
jail
sir.
during the coldest months of the year.
Yes, sir.
That's better than something.
I'm just really trying to get on my feet here and trying to do a lot.
Well, you also got 30 days of clean time.
Yes, sir. I mean, this is a great opportunity for me, and he's willing to help me out here, and I really would like to take it.
Ms. Hoff's sister is set for last pretrial next Thursday. If I'd had my waterfowl aligned, I would have set her for the same day. Looks like next Thursday is all Luke. Paul, are you available to do the sentence in this next Thursday at 3 o'clock?
I should be. I don't have my calendar in front of me, but I don't think I've got much.
I'm going to set this for sentencing for 3/12/26 at 3 o'clock. We'll try to get victim input.
You said you can check that.
At that point, you'd have about 36 days credit. That may do it, but I want to hear from her, at least have the opportunity to hear from her. The trees will still be there next Thursday.
I guess the defendant's asking if his bond could be amended to a PR bond and that he would appear at the sentencing date.
The answer is no. He's got $570 worth of unpaid fines and costs from a previous domestic assault and an assault and battery. What I'm probably going to try to do is wipe those fines and costs out when I sentence him next Thursday. Rather than set it for 10 days to the 16th, I crammed it in on the 12th. That's at least gives them an opportunity to try to get a hold of the victim. And I'll see you next Thursday at 3 o'clock.
Are you taking any medications?
Nothing other than ibuprofen and Tylenol.
Anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, sir.
If you enter a plea of guilty to this charge, I'm not going to sentence you today. I'm going to do pre-sentence investigation, set this for sentencing in about 4 to 6 weeks. Has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document here entitled Change of Plea and Entry. Looks like on the second page there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Hust before you signed it?
Yes, I did.
Are you satisfied with the representation that you've received in the case?
Yes.
You're going to enter a plea of guilty to 1 count of misuse of credit cards. This is a first-degree misdemeanor punishable by up to 180 days in jail and a $1,000 fine. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, has the state been able to confer with the victim regarding this case?
Yes, Your Honor. They understand what's going on and are in agreement with proceeding in this manner.
All right, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count 2, that on or about September 19th of 2025 in Deerfield Township, Warren County, Ohio, the defendant, James Thompson, made an unauthorized transaction with another individual's credit card.
Anything on those facts, Mr. Hust?
No, Your Honor.
Mr. Thompson, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the rights you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you may have been rejected here in open court. We're not going to go into the matter of the sentence today. I'm going to do a level 4 pre-sentence investigation. We'll see everybody back here. Actually, make that a level 3, Ms. Groko. Need to go back down to pretrial, fill out the paperwork for the PSI. See everybody back here in about 4 to 6 weeks.
Thank you, Your Honor. Thank you.
He's saying that he's not gonna release you today, but that's your sentencing day and you'll have approximately 36 days credit.
All right, while you're there, let's do Cameron Daughtry.
Wait, no, that's not it. I think it's that one. Yeah.
Good morning, sir. Are you Cameron Daughtry?
Yes, Your Honor.
I met you at your arraignment. You're charged with operating while intoxicated. You've been here all morning. We've had several of these today, which we generally do on these days. I click into your file. You got a ticket on January 1st. That's why the file number is so low. 26-22SD. This was a Cowboy Up case, Silver Street and Pinhook Road. Your blood alcohol was 0.12. Prosecutors agreed to dismiss the charge of operating while intoxicated for a plea to impaired driving. You saw me do two of these with the Mexican gentleman. Impaired driving is a lesser included charge of operating while intoxicated. It's punishable by up to 93
Service charge for?
Yeah, according to the.
Warren?
Yes, Judge Simpson, I'm
Okay,
here.
there you are. All right. What is plaintiff's claim?
Yes, Your Honor, we do show that currently there is past due rent in the amount of $4,815.89 with court costs the amount of $252.80 for a total due owing of $5,068.69.
All right. Ms. Warren, how are you intending on getting that paid?
I'm gonna try and reach out. I just got an email from the community manager, Ms. Feaster. She said that she may have another agency that could help me. And I'm doing the best that I can to try and come up with the money, but it's just
Okay,
really short.
I gotcha. Okay, let me ask you this. Do you, have you contacted Hawk or SOS?
No, last time I contacted Hawk, we were way over the income limit.
Okay, so you were over the income limit at that time.
Yes, but I did
Okay.
just get a payment yesterday from the Ann Arbor Housing for last month's rent.
Yes, they paid $2,999.68.
Ma'am, hold on a second. So has that been communicated to your attorney? Because I don't know where these figures, I mean.
I did. I tried to have the cases dismissed, but the cases weren't dismissed because they owed March rent.
Your Honor,
Right.
if I may
So-
briefly speak with my client, my apologies for the interruption.
Yeah, so here's what I'm gonna do. If there was a payment made and this is not the figure, counsel, I'm just gonna adjourn this out 1 week and,
Thank you.
okay, Ms. Warren, I'm gonna adjourn you out to the 13th, 2026 at what time? Huh? At 3 p.m. Okay? And, then we'll have the figures. We'll figure out what you're gonna be able to do and how we can get this done, okay?
All right, thank you.
Thank you. Lakestone Apartments versus Raven Hinton.
Attorney Samantha Sprague, I'm here on behalf of plaintiff.
Yeah.
I'm here.
Oh, okay, there she is. You got her iPhone one. All right. What is plaintiff's claim?
Currently restricted, there is a past due balance of $1,587.25 with court costs of $252.80 for a total due owing of $1,840.05.
All right, Ms. Hinton, how are you intending on getting that paid?
I paid it
I'm
this
sorry?
morning. I paid $17.17 this morning.
Your Honor, if I could get a brief moment to check, or if we could just do the 1 week adjournment and I'll confirm with my client that that payment has.
All right. So you think you paid this morning, ma'am?
Yeah, and then I
Okay,
have to
so-
work, so I don't. She said it was going to be dismissed today.
Ms. Hinton, hang on, okay? Let's do this, because if you paid this morning, then the number I have is not gonna be the correct number, but let's do this. I'm gonna adjourn it to the 13th, 2026 at, what time again? At 3 p.m., okay?
Okay.
And let them get the books reconciled. What I'm gonna suggest you do, that's an in-person hearing, but why don't you contact plaintiff counsel's office, all right, and see exactly where you are. And if you paid 1717, then you're about 120 some odd off. So maybe you can get that paid before then, in this case, can be dismissed.
Okay.
Okay?
Mm-hmm.
We'll do it that way. All
Okay.
right, have a good weekend.
You too.
Thank you, Your Honor.
Thank you. Take care. North Point Bank versus Maurice Warner.
Good morning, Your Honor.
And, oh, hang on a second, Counsel. I'm sorry, that's my fault. And Mary Ann McVoy and all other occupants. Go ahead, Counsel.
I apologize, Your Honor. Morella Albu for the plaintiff.
Stop smoking. So I took her video.
Okay, I got you. All right, there's a Nancy Warner. Are you on this case, ma'am? Nancy Warner?
Yes, I'm here.
Yes, I'm
All
here.
right, are you on this case?
On the paperwork I received, I'm considered the all other occupants.
So that'd be a yes. Okay. This is a termination of tenancy, counsel. What's the claim in this case?
Your Honor, we are seeking possession following a mortgage foreclosure.
All right. Ms. Warner, what's your position on that?
Your Honor, my husband passed away 12/23/23. We were married 2017. I thought that I would be able to take over as surviving spouse. I worked with North Point Bank, Washtenaw County Probate Court. I received the document, personal representative of informal estate. Dealing with my grief and depression, I have put the property for sale. I have a buyer. We were contracting up a purchase agreement. And that's where I sit right now. And then I got all this paperwork in the mail. None of it's addressed to me. Maurice Warner's deceased. Mary Ann McAvoy is deceased.
I'm sorry?
Maurice Warner and Mary Ann McAvoy are both deceased on this document. I'm the surviving spouse of Maurice Warner, and I tried to work with probate court, also with North Point Bank, to see if I could obtain some type of put my name on the deed or the mortgage. And I did not receive any help. I'm overwhelmed with this situation.
Okay, I get it. Are you gonna seek to have an attorney represent you, ma'am?
I don't know if I need a real estate attorney, a probate attorney. I don't
All right,
have the
why don't
funds
you-
right now.
Why don't we do this? You got something to write with?
Yes.
All right, I'm gonna give you two numbers, okay?
Yes.
All right. The first number I'm gonna give you is Legal Services of South Central Michigan.
Okay.
Okay, that number is 665-6181. That's 734.
Okay.
And the other number. University of Michigan number. The other number I don't have memorized, so. Okay, I'm gonna give you the number for the University of Michigan Criminal Civil Litigation Clinic. Okay?
Yes.
Okay, so here it is. It's 734-763-4319.
Yes, thank you. Great.
All right. And so here's what I'm going to do. I'm going to adjourn this out 1 week. You're entitled to that adjournment. So it'll be March 13th, 2026 at 3 p.m. That's an in-person hearing. Okay, try to contact them, tell them this is when you're set for, and then we'll see you then in person and we'll figure out where we're going to go from there. Okay?
Yes. Thank you so much for your time, Honorable
All right.
Judge Simpson.
Thank you. Take care.
Okay, thank you. Bye.
Bye-bye. Thank you, counsel.
Thank you, Your Honor.
Rajabi Rajabi versus Vance Wicks.
Good
morning, Your Honor.
Good morning. Mr. Rajabi, can you get yourself unmuted? Is he at ours? Or he's at 14.2. All right, can you, yeah. Okay, I see him.
Good morning.
Mr. Rajabi, hold down the space bar on the computer. Just hold it down when you're trying to talk. There you go.
Can you hear me?
I can hear you.
Okay, thank you. Good morning.
All right. So this is a non-payment case. How much are you claiming is owed?
Excuse me, would you please repeat your question?
You filed a non-payment of rent case. How much are you claiming is owed?
On the paper that you have in your folder, it is $4,983.92. However, last night I was doing all the touch-ups to get ready, and it came to $6,083.92.
$6,083.92?
Yes, sir.
Okay, does that include your calculation? Does that include March rent?
It includes everything, rent.
It includes everything. All right. Mr. Wicks, what do you have to say about that?
I have to say this person, I've already filed a police report with Officer Cammy. This person has nonstop harassed me. Actually, I don't even have a lease with him. I had a lease with his daughter, and he came back from Iran and she just kind of pushed him on me. And this guy has been 100%
Who pushed him on you?
I mean, saying you got to deal with him, not me anymore. So, but he's been nonstop harassing me. He comes up constantly unannounced. One day after the first day that I missed, he was at the door screaming at me, threatening me that he's going to turn the electric off and everything else. And it just.
All right. Okay. So let's back up because Mr. Rajabi, we've run into this before. Who is the lease with?
It's not with him. Sorry.
Mr. Rajabi?
I was in I want to make it really short. I was in my country, my native country, visiting in the summer, and unfortunately, the United States and.
Okay, that's a long answer to my question.
Okay.
My question is, who is the lease with?
The lease
with you?
The lease was signed by my daughter.
I have
Okay.
a copy of that too, Your Honor.
When I came back from my native country, my daughter says that, you have a tenant and from now on, he is going to pay you the rent.
Who owns the property?
I own the property and the bank.
But the lease is between this gentleman and your daughter.
Yes.
She needs.
May I please? I did tell him that I would like you to fill out an application form with your social security number so that we will have a lease, a new lease. He refused to do so.
Well, what's wrong with the lease he has?
Excuse me, Your Honor, my daughter just called me. I wonder if she's going to to say something about this whole situation. Would it be okay if I?
No. We're not going to do it that way.
Okay.
Here's what we're going to do.
Okay, go ahead.
I need all of the proper parties here. That's going to include your daughter. If you want to come down, you come down, and Mr. Wicks. So I'm going to adjourn this out 1 week.
May I?
To March 13th, 2026 at 3 p.m. That's an in-person hearing. So everybody needs to come down to the courthouse. Bring all of your paperwork and everything. I'll take a look at it and we'll figure out where we're going to go.
May I make a motion, Your Honor? May I make a motion?
May you what?
I would like to make a motion. May I?
Make a motion?
Yeah. Make
to
a
do
request.
what?
Could you please ask him to at least put in an escrow account that the rent he owes me so far, when we come back, it's going to be up your judgment what is going to happen to that money. Because I think he's dragging his feet not to pay rent and stay in my house.
So first of all, I can't order that at this hearing.
I see.
All right. I don't even know. I heard what's owed or what's been said is owed, but I don't know that I'm talking to the proper party in interest, which may be your daughter.
Okay.
So I'm not going to do anything. I'm going to wait, see what the lease says. You and your daughter need to come down with a ledger that's going to show me the amounts that are owed, and then we'll figure out where we're going to go from here.
Okay. May I please say one more thing? Utilities.
I can't stop you. Go ahead.
I'm sorry. Your Honor, utilities are not in his name. He's supposed to put them in his name. And he keep telling me, if you shut off the utilities, I'm going to take you to court. I have no intention of shutting off the utilities. I'm a landlord. I know what happens if I shut off the utilities on him. And DT has contacted him, and he's not anything but utilities.
Okay, there's nothing I can do with that.
Your Honor, may I say something? May I ask something?
I really would wish you wouldn't, but go ahead. He's gotten to say something.
I just want to know what I got to do to have an attorney represent me. I mean, can I have one appointed?
Okay, you can. Okay, so you're going to try to get an attorney. You can call legal. Okay, hold on, folks. You can call legal services. You need that number?
Yeah, can I get it?
Yes, it's area code 734.
734.
665.
665.
6181.
6181. And what is the name of the organization?
That's Legal Services of South Central Michigan.
South Central.
Okay, you can call them. The other place you can call is the Michigan University of Michigan Criminal Civil Litigation Clinic. Their number is, I just had it. I don't have that one memorized. It's area code 734. Hang on. Area code 734-763.
4319.
4319.
I got it, sir.
You got it?
Yes,
Okay.
sir.
So you can call them. I'm going to mark the file that you may get an attorney. And we'll see you guys next week at 3 p.m. in person. I can't wait. Thank you.
Thank you.
All right.
You're welcome. Have a great day, sir.
You do the same.
I'll try. I had to leave
All right.
for today, so. Oh, one more thing. I have never been served a process, period. This person right here has gone through my mail. I got a picture of it. He took my mail out of the mailbox and put it on my car. And furthermore, I just getting off work yesterday, happened to notice this thing in the mailbox, which
what thing?
Less than this summons, less than 24 hours is what I had. I got off work at 2 o'clock yesterday to see this. I had to take off work today. And nobody ever, I haven't seen a process server. I get random people banging on my door with this guy screaming all the time, constantly, to the point where I won't answer the door. Your Honor, one more thing and I'll be quiet. I've been in therapy for PTSD for over 2 years now. I've been in therapy for PTSD for over 2 years now. My doctor's Dr. Brower. I just had an appointment Wednesday. This person has gone above and beyond, threatening me and making my life a living nightmare.
Oh my God.
And he's not even, we don't even have a lease together. So please, I need help to.
All right. So first thing you're going to do is try to reach out to attorneys.
Yes, sir.
And then, Mr. Rajabi, I don't want you over there in the interim week. Do not go over to the property.
Thank you, sir. I
Your
appreciate
Honor,
it.
when you give me under oath, I will tell you whether he's telling me the truth or not.
Okay, but I'm not there yet.
Okay.
I just need to keep you two apart from each other for the next week until you're in person before me. That's all I need to have happen. Just don't bother each other.
So I haven't seen him in 2 months. 2 months, Your Honor.
That's a lie.
I swear
He's
to
there
God.
every single day.
Every single day.
Yep.
Okay. Thank you, Your Honor.
Really? Are we done now? We'll see you next week. Stay away from each other until you get to the courthouse. You understand that? That's an order.
Yes, sir.
Does that mean he's going to be on the property still?
Just shut up.
I'm sorry, Judge Simpson.
No, don't tell him to look, both of you. You want me to bring you down here today? Because if I bring you down here today, it's not going to end well for anybody.
Okay.
No, sir.
Didn't think so.
Thank you.
So stay away from each other. Be quiet. Have a great weekend. We'll see you next week.
Thanks a lot, Judge. I'm sorry for all the.
Bye.
inconvenience.
Goodbye. Is that all I got? We're